All right, now to judges and judging. So, how do judges make decisions? This is going to be political science. This is going to be the first political science of the class. Um, there are more or less two theories about how judges make their decisions, how judges come to decisions of law. The first one of those is called by political scientists mechanical jurisprudence. Another way to think of this is to simply call it the law school and legal education model. And the reason for that is this is the model by which you will learn in law school that law is made and judges make decisions. What it says is that judges take the facts of the case, apply the applicable law, and therefore make a decision. So it's mechanical, that anyone could do it correctly trained by looking at facts, the stimulus of the case, applying the applicable law, and therefore outputting a decision. So it's mechanical. That's how most people are taught, and that's how most people, if they don't believe, at least think law should work. There are monumental problems with that. Um, Political science has developed a different model. It's called the attitudinal model. The attitudinal model says, forget the case facts, forget the law, and if you want to predict how judges make decisions, understand what their ideology is. So that the attitudinal model says that judges make decisions based on their ideology. In fact, the attitudinal model in its sort of what I would call naive sense says that judges make decisions solely based upon their ideology, that the law doesn't matter, that the case facts don't matter, that all that matters in terms of predicting Supreme Court outcome is what ideology the judge has. That sounds really reductionist when you hear it for the first time. But we can predict, political scientists can predict, around 85 to 90% of votes on the US Supreme Court by using one variable, and that variable is their ideology. So, yeah, it sounds really reductionist, but it's also strangely and powerfully accurate. Now, is that good for judging? Probably not, but try to think of another way in which judging could work. As long as you put individuals with a large amount of freedom, what we consider to be important, judicial independence, to make decisions, also they become independent from external retribution. So for example, our judges on the federal judiciary have life tenure and can only be removed through impeachment. And added upon that, it's very, 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 very rare that judges are removed from impeachment. So what this means is that you have unaccountable judges to anyone able to make decisions. I don't think we would expect anyone to be in a position where they're unaccountable and also independent enough to make decisions in some sort of disciplined fashion. We would expect them to make decisions based upon their own whims and interests. And so to a large extent, that's how judges do decide cases, is based upon their ideology. But there are elements of mechanical jurisprudence that are true. And we've sort of learned that watching the proceedings of the election cases, the Trump cases that were alleging election fraud. Almost all of the cases were thrown out because the individuals bringing the suit didn't have standing in order to bring the suit. So that is not an attitudinal decision. That's a mechanical sort of decision. You look at the facts of the case, you apply it to the particulars at the hand, and you make a decision. So what we witnessed were a lot of what we would consider ideologically conservative judges who would probably have been much more comfortable with a second term for former President Trump as opposed to a new term for President Biden. They made a decision that was against their ideological interest, and looked much more like law. I'm going to pause here as there's someone knocking on my door, which is very awkward, but I'll be right back. And the only reason I paused that recording is so you all didn't hear me say, go away to strangers at my door. At least, on the internet for perpetuity. So back to where we were. So this attitudinal model is pretty much how judges work. It's how judges sort of make decisions and prescribe themselves. But it's not necessarily fulfilling or good. So in political science, we sort of developed this third way. And this third way is called strategic behavior. And this strategic behavior basically takes elements of mechanical jurisprudence and elements of the attitudinal model and puts them together in a much more meaningful way that says that most judges make decisions based upon solely their attitudes. However, they will also incorporate mechanics of law primarily because employing those mechanics of law lends legitimacy to their decision. And legitimacy is the currency of the courts. And we'll refrain back to that here fairly soon. So in the U.S., we have what is known as a common law system. There exist other legal systems throughout the world, but here in the U.S., we operate under a common law system. And a common law system is unique because not only do judges decide cases, but judges decide cases that make law. So when a judge issues a decision, that decision becomes precedent. It establishes precedent, and that precedent is the same level as a legislatively made law. It's law. It's enforceable law. And our common law system, because we have a hierarchical system where we have a Supreme Court at the top, appellate courts sort of in the center, and trial courts at the bottom, decisions of the United States Supreme Court are binding, therefore controlling, upon all of the lower courts. So when we talk about this sort of attitudinal model versus mechanical jurisprudence idea, at the top level, the United States Supreme Court is much more likely to employ the attitudinal models because they have no restrictions. But those judges who sit beneath them, appellate court judges, they're bound by the decisions of the United States Supreme Court. So they're much more likely to employ mechanical jurisprudence because they don't want their decisions overturned by the U.S. Supreme Court. So the nature of common law in the United States sort of means that the most independent judges, being those who sit on the U.S. Supreme Court, are much more likely to employ the attitudinal model, where judges on lower courts, appellate courts, and trial courts are much more likely to employ mechanical jurisprudence. So I want to sort of establish this from the get-go. There's a lot of debate about what it means to be a judicial activist. And judicial activism in our time and space has come to mean one thing primarily. When we say that a judge is activist, it carries with it an ideological connotation. What we mean is that judge is liberal. And the reason for that is Republicans over time have very, very, very well promoted this idea that the liberal judges are activist and legislating from the bench. In fact, you've probably heard that term before, legislating from the bench. But the actual reality of the situation is much more complicated. Judicial activism has a definition beyond how it's been used and how you heard it used. And here's what judicial activism actually means. A judge engaging in judicial activism overturns legislatively made law. That's what it means. So when you extract the definition from our current connotation, you can see that both liberal and conservative judges can simultaneously be activists. As long as they're overturning legislatively made law, they're an activist. And so this debate about whether judges make policy or judges simply issue decisions, there should be no question. The decision of a judge is binding precedent. Therefore, it's policy. They're also lawmakers in that they can determine whether something is constitutional or unconstitutional and change the law of the United States in one fell swoop. That's making law. That's making policy. That's not being activist. It might be an activist act, or it might not. So let me give you an example of what that looks like. Let's say the federal government passes a law, and it comes before the United States Supreme Court to be challenged. And the United States Supreme Court upholds that law. Let's say it's a liberal law. Like, we would look at it and go, well, that's a liberal decision. Well, it's not activist because they sided with the legislature. They agreed with what the legislature said. Even though it's a liberal law, agreeing with the legislature is not activism. So let's say, for example, there's a conservative majority on the court and they overturn the decision of a Democratic legislature. Big D, not small d. So a legislature majority of Democrat. That's activism. And that would be activism by a conservative court. And so I really want us to stick away from the idea, and even in your personal lives, of using the term judicial activism, because it means very different things depending on who you're talking to. And very few people use the terminology as sort of legal academics and political scientists use it, which is to say judicial activism is overturning legislatively made law. Most people use it to mean that it's a liberal decision. But that's not the case. And in fact, we'll look back on courts in the course of this class that were being extremely activist, but were also simultaneously conservative. So just want to get that out of the way. Any questions about this first part before we go on? If you're interested in basically taking an entire course on how judges make decisions, which is basically what I do for a living. In political science, we offer a course called Judicial Decision Making. It's a 4,000 level course that I try to offer once a year, at least during normal times, that looks at the literature developed by political scientists and lawyers on these sorts of questions. All right. So how does the Constitution change? One way is through state Supreme Courts. So when you have state Supreme Courts making a decision, and I'll say this and you'll all probably make a face, there are 52 state Supreme Courts. That's not a mistake. There are 52. Texas has 2 state Supreme Courts, though one is called the Texas Court of Criminal Appeals. And Oklahoma has 2 state Supreme Courts, though one is called the Oklahoma Court of Criminal Appeals. And the reason why Oklahoma has 2 state Supreme Courts is because they have a strong desire to be Texas. They have no other reason why they should actually have 2 state Supreme Courts. Texas does it because we have so many cases, and it sort of makes sense. Oklahoma does it because they envy Texas. So when we talk about revolutionary decisions, a lot of these revolutionary decisions that ultimately get carried to the U.S. Supreme Court and change the way we sort of understand the Constitution, they come from state Supreme Courts. And that's because state Supreme Courts are technically what we call courts of last resort. So they're the courts where the appeal goes last. So the way that would work is that, we'll take Texas as an example because Texas is easy. A Texas trial court makes a decision. That decision is appealed to a Texas appellate court. And then that decision is appealed to the Texas Supreme Court. Now, through all of that timeline, through all of that process, the issues that are being resolved have to deal with state law or state constitutions. So let's say the Texas Supreme Court makes a decision interpreting the Texas Constitution in a certain way. Well, if there also exists a federal issue, so let's say the party loses on a state constitutional issue, but there also exists a federal issue, they can then appeal to the United States Supreme Court, and the United States Supreme Court will settle the federal question. Through this process, a lot of the developments that we have seen the U.S. Supreme Court made have started in state Supreme Courts. Miranda v. Arizona, for example, started in a state Supreme Court. And and ultimately goes to the U.S. Supreme Court and makes a revolutionary decision that started within the states. So one way that we can see constitutional innovation, that we can see development, is through state Supreme Courts. Another way is the Supreme Courts can look out into the population and sort of emulate certain things that are going on. So I use here as the exclusionary rule as an example. And the exclusionary rule basically says that certain evidence can be included in trial despite the fact that there technically was no warrant and it would be constitutionally an illegal search and seizure. You'll know these as exceptions to the exclusionary rule. One that I think all of us and everyone in the world should know is the plain sight exception. So an officer walks past your car, you have some form of contraband in your car. The officer absolutely does not have a warrant, but you were a moron and you left it in plain sight. So the officer does not need a warrant to actually confiscate that item and arrest you. That's a plain sight exception. The way by which the Supreme Court has developed a lot of these exceptions has been looking to state courts and also lower appellate courts in the federal system and seeing the exceptions that they've adopted and emulating them. And this is sort of what democracies generally do. The federal government does it all the time. So the federal government has to make a policy. One of the ways where it can develop an innovation is to look and see how the states handled an issue. And if one state handled it particularly well, then the federal government might adopt the way that state was doing. And in the same way the Supreme Court does with the exclusionary rule. And the reason why SCOTUS often emulates is because it's a time-saving device, primarily. And also other people probably got it right before they did. The Supreme Court, by its very nature, is very slow to act. Outside of a few cases that are going to be heard this year that have already been heard starting in October and will be heard through at least March, very few of them are current, meaning that the Supreme Court is resolving issues that started, in most cases, over 5 years ago. Like the original trial for these cases was at least 5 years ago. Supreme Court moves slow because of the way the cases have to percolate up through the system. State courts don't generally have that restriction. They're usually much faster. Appellate courts, lower federal appellate courts, are usually much faster. And the reason why the Supreme Court emulates is oftentimes these courts get to issues much faster than the U.S. Supreme Court will. So it's a time-saving device, and also it leverages what other courts have already done. So it's a smart thing for the United States Supreme Court to do. But when it comes to interpreting the Constitution, and I'll welcome you to go look and read through it, there's absolutely no part of the Constitution that is very clear on who should decide what the Constitution means. It's not in there. It doesn't say. The oath of office says that you have to uphold the Constitution, which some have taken to mean that also gives you the authority to interpret what the Constitution actually means. So it isn't clear that the court should do it, that the president should do it, or that the Congress should do it. None of it is straightforward in who has the authority to interpret what the Constitution means. Now, this might sound odd to you. In fact, it would sound odd to regular Americans if we were talking about this in a sort of real fashion, because everyone just sort of knows that courts get to interpret the Constitution and decide what it means. But that's not necessarily the way that it has to be. The reason why the courts get to interpret what the Constitution means is they asserted it as their right. They said early on, hey, we have the authority to do this. And the other two branches of government didn't fight it. So we exist in an environment where we sort of accept it. We accept the fact that the United States Supreme Court and other courts interpret what the Constitution means. But that necessarily doesn't have to be the case. That doesn't have to be the rule in this regard. So the fact that we've sort of defaulted to that is just a circumstance of our history. And there are other systems of government, other countries, who don't place their court of last resort in the authority of deciding what their constitution or what their main governing document means. We just do it a different way. And lots of countries have emulated the way that the U.S. Supreme Court does it. But there are other ways to actually go about this process. Questions? Because I need a drink. All right. So the process by which the Supreme Court and all courts review laws to determine if they're constitutional or unconstitutional is known as judicial review. Judicial review is the mechanism by which courts use to engage in the review of laws and executive orders to determine whether they run afoul of the Constitution. The formal definition of it is the authority of a court to review the acts of an executive or a legislature and potentially declare them invalid. That's what judicial review is. There are exceedingly powerful critiques of judicial review. I'll give you just one of them now. Judicial review gives the authority to determine what laws are legal or illegal based upon the Constitution by mere interpretation. The power is thus, at least in our system, given to 9 individuals who are not accountable to anyone. And therefore, the ability to directly influence what the court thinks is almost impossible. So what happens when the U.S. Supreme Court interprets the Constitution to mean something that is overwhelmingly impossible, or not impossible, overwhelmingly unpopular? And the answer is there exists no mechanism to do that. It simply does not exist. The only way in our system to effectively change what we think the court should do is wait until members of the court retire or die. That's it. Or increase the size of the U.S. Supreme Court, which Congress could do statutorily, since that's not written down in the Congress anywhere, or written down in the Constitution anywhere. So the critique of judicial review in this environment is that, man, we give a lot of power to these people who are absolutely accountable to no one. And if you've lived long enough, as I have, and lived through liberal courts and conservative courts, the critique becomes even more damning, because right now, if you're a conservative, you might be absolutely all right with the Supreme Court having this authority, because there's a majority of conservatives on the court, and therefore they're much more likely to decide these cases in a conservative fashion. But those same individuals would be probably a little reticent about judicial review if there was a majority of liberals on the court. And so judicial review given to a court, especially in the sort of fashion that we have, that courts that are unaccountable and very difficult to change, might be seen as problematic. Especially when you consider that these judges don't operate under mechanical jurisprudence, but operate instead under making decisions based on their ideology. Because if it was mechanical jurisprudence, who would care if they were as independent and as unaccountable as they are? Because mechanical jurisprudence says that individuals, especially these judges, would come to very similar decisions given all of the stimulus that they get. But we simply know they don't. And we know that something else influences them, and that something else almost always is ideology. And so we've pinned this idea of judicial review on the courts because at least we like to think of courts as unbiased and independent arbiters of what the law is. But in actuality, we know they aren't, which is, by the way, why we fight so hard over Supreme Court appointments, is because we know how much it matters to have a majority on the Supreme Court. Yet we give this court willingly judicial review. based upon, at least in part, an assumption that they're independent arbiters of the law, when simultaneously we hold the same belief that it really, really matters who's on the Supreme Court, because that's going to really affect how they make decisions. So judicial review might not be a good thing. Might not. In fact, I would say it probably isn't, but this is where we are. So there's really only one restriction on this. Really only one restriction on it. And that's the court's legitimacy. So Alexander Hamilton wrote that the court possesses neither the purse nor the sword, but merely judgment. That all it has, its only tool, is that it can sit in judgment. And what does it mean by not having the purse and the sword? What it means is that the court can't spend money. The court can't enforce its decisions. All it can do is make decisions. It's dependent upon the other two branches of government to actually enforce those decisions. The executive branch has to be the ones who enforce in terms of decisions when it's a criminal sort of issue, and Congress, because of its power to spend, has to enforce other types of decisions. So if the U.S. Supreme Court makes an exceedingly unpopular decision, how would it get enforced? And the answer is, it doesn't have to be. It simply does not have to be. Andrew Jackson, perhaps, is most notorious for this, having said, or the Supreme Court has made its decision, now let's see it enforce it. And so we could be put in a situation by which the Supreme Court makes a decision and the other branches of government simply choose to ignore it. Well, that doesn't happen all that often. In fact, it's exceedingly rare that happens. And the reason for this is all judges, but especially judges on the U.S. Supreme Court, understand that their decision is only as good as the degree to which members of society view the court as legitimate. Legitimacy is a real sticky and difficult idea to get around. But basically, legitimacy is the belief that an institution of government is the correct institution to make a decision. It's not necessarily agreeing with the decision it makes, but it's the recognition that that institution has the authority to make that decision. And Supreme Court justices are very careful to sort of court this view of legitimacy. I don't know if you were paying attention yesterday during the inauguration, but there was some very, very specific legitimacy courting going on by the U.S. Supreme Court. There were 3 members of the U.S. Supreme Court who weren't in attendance yesterday at the inauguration. One, Justice Breyer, a liberal, probably not there for a majority of reasons, but the most likely being he's exceedingly old and COVID would probably kill him. The other 2 who weren't there were Samuel Alito and Justice Roberts, who probably the most conservative individuals on the bench. But you know who were there? Our 2 new Supreme Court justices. They showed up. They were there. They took pictures. There was the whole thing. So you had Brett Kavanaugh at the inauguration. And that's legitimacy courting. That is very much an external signal to the public that we're trying to build up the public's goodwill in us, because they might make decisions in this upcoming term or next term that are unpopular, at least don't go along with what the executive and legislature would want. But the public most likely will still probably expect the president and the legislature to enforce the decisions of the Supreme Court. And that's because they're seen as legitimacy. So what happens when the Supreme Court loses its legitimacy? Well, then the other 2 branches of government don't necessarily have to follow it. And so this legitimacy is sort of a real concept that actually worries judges. And it's really their only check on the overuse of judicial review, is this idea of legitimacy. And while it is an abstraction, I can tell you quite vividly that judges worry about this. Question from the chat. What do political science think about packing the court? So I can reference it to this idea of legitimacy. The reason the Supreme Court is seen as legitimate is because, at least in large part, it's viewed as being independent and not a political branch of government. Now, political scientists know that the Supreme Court and the judiciary more generally is absolutely a political branch of government. They make decisions. They decide policy. They absolutely act politically. But this idea of legitimacy sort of hinges on the idea, at least among the populace, that the Supreme Court is independent and sort of free from political influence. So I would say that political scientists, let's separate them into two groups, because this has been my experience, at least this past year, with the discussion of court packing. There are two groups. There's those of us who study the court, and then there's other political scientists. And those of us who study the court, a small number of us, I think almost overwhelmingly we're against the idea of court packing. And that's because it would damage the legitimacy of the court. The reason why we follow the court, the reason why we listen to court decisions, the reasons why we do all this is because we view the court as legitimate. Because without that legitimacy, there's nothing that would stop a President Trump or a President Biden or a President Obama or any president ever from just ignoring the decision of the court. Once a court loses legitimacy, there's no reason to follow it because they can't enforce anything. They just simply don't have that ability. And losing legitimacy of court is something that's very, very, very difficult to get back. So those of us who study courts were very wary of the idea of packing the U.S. Supreme Court, even though, and this won't shock anyone, the majority of us, those of us who study the courts, are probably liberal, and we realize that the Supreme Court now has a conservative majority, which will probably mean that there'll be a lot of decisions we don't agree with, and still we think you shouldn't pack the court. So that should be sort of telling. But regular political scientists who don't study the court, they're more for it. They're more for it. And I think that's because they really haven't grasped or really tackled this idea of legitimacy and what it means. Because if you pull these strings of legitimacy, if you start tugging on them, the entire premise of our U.S. judiciary just sort of falls apart. At least the federal judiciary. State judiciaries are very different. Just sort of give an example of that. What happens if the legitimacy of the Texas Supreme Court declines? We elect a new Texas Supreme Court. The Texas Supreme Court doesn't get its legitimacy from this sort of wellspring of goodwill. It gets its legitimacy because it's elected, because a majority of individuals chose those individuals to be on the court, the same way as all of our elected officials get their legitimacy. So legitimacy at the state level looks very different from legitimacy at the federal level of the judiciary. And so those of us who study courts are a little reticent on the idea of court packing because it really damages this idea of legitimacy. Other questions about this idea of judicial review and how legitimacy sort of feeds in it, and the playback of all of that? Okay. Well, and a normative question, of which I won't give you many. Does an unrepresented branch of government really have this much power? And the answer is, yeah, it really does. We have a very unrepresentative branch of government that has a boatload of power. Yeah, Mary, go ahead and ask your question. So that's part of it. The other part of it is generally we view, and when I say we, I'm using America sort of collectively, the court as almost an apolitical branch. Like we hold two simultaneously like conflicting views. One, the court is an apolitical branch of government. Two, it really, really matters who's on the U.S. Supreme Court. And I think if you talk to most individuals, and in fact, I know because it's borne out through survey data, most individuals hold those two simultaneous views. And they're conflicting, but they still hold them. And so if we were to inject politics much more overtly into the judicial branch, then the view that the court is apolitical would dissolve. Now, is that necessarily a death knell for legitimacy? No. We have very overt politics in some judiciaries. For Texas, for example, like we elect the court. It's very clear that politics is involved in that. But it gets its legitimacy through those elections. So if you simultaneously have a life-appointed or a life-tenured unaccountable judge, unaccountable court, but you then pack the court, what you're doing is you're stacking the deck. And it'll be viewed as stacking the deck. And therefore, the legitimacy of that institution will decline. And once you get to here, there's another thing. You can't unring the bell of court packing. Once you pack a court, that play in the playbook is open forever.
Yeah. The next administration do the same thing.
Exactly. So, like, let's say, for example, since there is a unified government, so there's Democratic president, Democratic House, Democratic Senate, they could absolutely pass a court packing bill and just say, hey, on the Supreme Court, we're going to add, 5 more nominations, 5 more seats. Well, let's say that in 4 years, they lose that majority.
Right.
Well, as opposed to impeachment, which is actually more difficult, impeaching a judge is more difficult than adding more seats to a court. Well, then the next administration comes in and says, well, guess what? We're adding 5 more. And then you have a court that has 25 members on it. And no one views that court as legitimate. They're just like, oh, this court is just put in power to rubber stamp whatever the presidential administration wants. And so those of us who study courts are kind of like, that's not great.
Do it again.
All right, another question from Brian. Thanks, Mary. If you could just go ahead and mute yourself so it's not in my ears. Would a heavily skewed court damage legitimacy? If they make decisions that do not conform to the popular opinion. And so here's another aspect of legitimacy that's kind of important. I don't think that this court is going to be viewed as illegitimate. It's going to be viewed as conservative, no question there, but I don't think it's going to be viewed as illegitimate. And the reason for that is the majority of the time, in fact, the overwhelming majority of the time, the Supreme Court makes decisions that are 9-0. Like, you don't hear about them. They're not there. They're not something that's reported on. But in any given term, usually over 60 to 70% of the decisions are unanimous or have one dissent. And that's controlling for ideology, and that's looking at the court going as far back as we can. And that's because a lot of the decisions the court makes are really easy. Furthermore, there's no real easy way for me to give you this besides saying you need to look at what Justice Roberts has done. Justice Roberts has decided some very clear, and it's pissed off conservatives, but he's decided some very clear cases in which the policy itself was popular in such a creative fashion as to clearly being an attempt to court legitimacy. Just look at the healthcare decision. Like, he invented in his decision something that absolutely was not argued by either side. And he did so that he could get to the decision that he knew was popular in a way that he could at least constitutionally argue it. I think judges worry about this. And because of that, their ideology is to some extent constrained. Let me put it more differently. I don't think Justice Thomas or Justice Alito gives a shit about legitimacy. They're extreme. By the same token, I don't think Justice Breyer or Justice Ginsburg, when she was alive, cared at all about legitimacy. They didn't worry about it. But your judges more close to the center, your Justice Roberts, your Justice Gorsuch, Justice Sotomayor, Justice Kagan, who are more closer to the center than their extreme colleagues. I absolutely think they worry about legitimacy. And I think what we've seen in recent decisions is we've had really strange bedfellows in some decisions, and we've had some really strange bedfellows in some dissents. Like if you read a dissent to a case and it's Justice Sotomayor joining a dissent of Justice Gorsuch, you should take a step back and go, what is it they're doing? If these two judges agree, which ideology says they shouldn't, in fact, we understand those two judges shouldn't agree on stuff unless everyone's agreeing on it. I think the judges really care about legitimacy. So even if there was a 7-2 conservative court, no, I think they're going to care about legitimacy first. And they'll press their policy advantages in areas where they want to. But I don't think that they would run amok. And I only have to really jump back to the 1960s when we had an overwhelmingly liberal court that carved out its liberalness in only one area, and that was civil rights. It was relatively sort of centrist and sometimes conservative in other areas. But it was very out there on civil rights. And the reason why it did that is it had to maintain its legitimacy some way. And it certainly wasn't doing it on the civil rights area, but it was doing it everywhere else. So I think judges really consider this and really worry about it. So I wouldn't see a very skewed ideological court as being a problem unless the judges on that court started behaving in a way that really clearly signaled they didn't care about legitimacy, which I've never seen evidence of. Other questions? All right, cool. History of judicial review. I think last.
Sorry, I have a quick question.
Go right ahead.
So you mentioned that one of the biggest worries about the Supreme Court is that they have no accountability.
Mm-hmm.
Has there ever been a big push to give them term limits or some sort of a limit on how long they could be there?
So this one pops up not trivially. So to answer your question, yeah, there's been discussions of it, primarily among law professors. And the law professors basically say that, if we gave them for something like 18-year terms, so terms that are just so long that it doesn't we wouldn't be worried about their independence being shattered, that would be long enough, and it also would provide enough turnover on the courts that courts would remain current. Because one of the big critiques of these courts is that life tenure matters a whole hell of a lot, but it's really different when we're talking about life tenure for a judge who joins the court at, let's say, age 65 versus life tenure for someone who judges the court at, let's say, age 42. That's a very different discussion. So when we talk about people who sit on the court for 30, 40 years, that's pretty monumental. One thing we know about most people, judges included, is that they don't ideologically evolve a lot once they get past a certain age. I'm pretty much set in stone. I'm going to be this ideology for probably the rest of my life because, whatever. This is where I am. But you all, those who are younger than me, your ideology is going to change. It's going to be flexible to some degree or extent. So when you put someone who's my age on the court, I'm 41, by the way. So I would be the youngest, but I would be the youngest by 2 years. And you say, hey, you get life tenure. Well, damn, I'm going to try to live time 90 something. I'm going to be on the court for 50 years making decisions. Now, do you want my curmudgeonly ass making decisions when I'm 90 years old on a court that's going to be making decisions that I can't even envision right now? The answer to that's probably no. So term limits have absolutely been discussed. The problem is with actually getting them passed is it's going to be political. If there was some way that we could pass this and simultaneously kick everyone off the Supreme Court and draw a new slate of individuals, it might get passed. But right now there's a conservative majority on the court. Many of those conservatives are young. So if we were to institute term limits, what that would mean is conservatives would lose out on their members being on the court for an extended amount of time. Liberals right now are all for term limits. Most members of the court that are liberal are ancient, like Justice Breyer. I'm shocked he hasn't sent Biden a letter already retiring. So, yeah, it's going to become political. The problem is it shouldn't be political. It should just be good policy. We should probably give these people 18 years terms, stagger them, and therefore it'll revitalize the judiciary. It'll bring new thoughts, new mind, all sorts of good stuff. But the problem is that when that comes buttressed to reality, the decision to do so is going to ultimately be political. And since there is a conservative majority on the court, Republicans aren't going to want to support it. And that's not a slight against Republicans. If you have power, try to keep power, especially on the courts. So it's one of those things where it's good policy, and I think overwhelmingly people support it. And this is kind of where law professors and political scientists who study courts kind of butt heads. I absolutely agree with everything law professors say about term limits and why they would be wise. Problem is, I take the next step and go, but it's impossible because politics won't let it happen. So it's something fun to debate, but it's never going to take place because passing a constitutional amendment, which you would have to do to create term limits, it's never going to happen. It's legitimately impossible. It's politically impossible. Any other questions? Okay. So we're going to do a little bit of history of judicial review, and then I think it feeds right into Marbury v. Madison, which is where I told you all I was going to leave off, which is fine because we have 5 minutes. So I'm going to do this slide, and then we'll be on our way. So judicial review kind of existed. It didn't really exist in any court in a formal sense, but it kind of existed. And the first place that we really see that if we draw back a line to try to find where judicial review started, the first place that we can really see it is this case coming from England called Dr. Bonham's case. And Dr. Bonham's case involved interpretation of a law and Justice Coke reviewing it against all relevant rights basically said, well, the law has to be invalid. It simply can't apply in this case because of reason X, Y, and Z. And so he asserted this authority that judges not only get to decide cases, but also get to determine if a law is legitimate or not. Now, Chief Justice Coke, that didn't go over so well, and this idea sort of evaporated in the English judiciary. But it's something that our founders knew about, and when they brought over, at least it was a thought in their head. The adoption of judicial review in the U.S. isn't at all immediate or obvious, but it was something that we at least had a very familiar history of. And the easy way to sort of look at this is to look at what we did during the Revolutionary War when Britain started passing all of these acts that we notoriously didn't like, Tea Act, Stamp Act, Intolerance Act, lots of others. What we said is that they're null and void in our borders, that they're invalid, and they're invalid because not that they offend any sort of constitution, which didn't exist, but our founders would say that they offend the very nature of man. They offend the rights of man. Well, that's very much a sort of a judicial review-y type action, because what they did is they took a relevantly made statute and interpreted it against some other document and said, well, that's just null and void. We don't see that it has any legitimacy. And judges still do that, by the way, because they're, as very clear, we argue that there are certain things that are called inalienable rights that aren't written down in the Constitution, but still exist. And judges can interpret against these inalienable rights, even though they aren't written down. So we at least have the background of the founders absolutely knew that this idea of judicial review existed. Furthermore, they engaged in a practice very similar to judicial review throughout the Revolutionary period. It hadn't been adopted by any country as a point of law. It didn't exist anywhere, but the idea was fermenting. It was kind of boiling up. But it's not at all clear that the founders had any intent of judicial review being a power of the courts. And the reason that we know that is because judicial review was discussed. They talked about it during the Constitutional Convention, and yet it does not enter in the actual document. And the reason for that is because Federalists and Anti-Federalists very much differed on what they thought the power of judges should be. And so we get through the constitutional period, the drafting and the ratifying of the Constitution, and you can tell. Go back and look at Article 1 for the legislature, Article 2 for the judiciary, and Article 3 for judges. Judges are so much an afterthought of our founders that it's not even funny. Article 3 has 3 clauses, and they're brief, and they don't tell us a lot. And that's kind of why the courts had to carve out their own path in terms of what it was they want to do. To put more fine tooth on it, and where I'll end off today, is that upon the ratification of the U.S. Constitution, our first Chief Justice was John Jay, one of the authors of the Federalist Papers, one of the founders. He was the first Chief Justice of the United States. He very quickly retired from being the Chief Justice so that he could run for office to be the governor of New York. The Chief Justice of the United States retired because he had nothing to do. There was basically no job, because the Constitution didn't provide any guidance on what judges should do under the federal Constitution. Where we'll pick up in the next class is we'll enter into the early 1800s, 1803, and we'll talk about Chief Justice John Marshall and look at how he revolutionized the courts in the United States and in large part changed how Americans think about the judiciary.